Welcome back, everyone. Frank Ravitch and I are speaking about some of the more interesting, the cases that we find the more interesting in the casebook. Again, 4th edition, newly published, buy one, buy them all, and consider teaching and learning law and religion from them. Today, we've got what I think are two really exciting cases. And the cases are, for me, exciting because they're like, what happens when the court rules, and then you're going to spend all of your time figuring out how to get around it. And we're going to be looking at the Santa Fe Independent School District versus Doe case, and which is a moment of silence in the elections.
It's a school prayer.
Santa Fe is
the school prayer. Wallace is
and then and then the Wallace versus Jaffrey, which is the school prayer case.
So Wallace is the moment of silence.
Right. So my first question to you: how do you teach the two cases?
You know, it's interesting. I draw a line from Levy-Weissman to Santa Fe, right? Because a lot happened. In fact, I was actually in practice at that time and had some school boards. The firm represented some school boards, and this letter went around after Levy-Weissman was decided from the American Center for Law and Justice, telling everyone, you can still do voluntary student-initiated prayer. And, you know, my instinct as a young lawyer was no, because, the election is sponsored by the school, any policy that would allow that. And if you're relying on free speech, then you have to allow, even if it's a limited public forum, you'd still have to allow dissenting student speakers. And so I remember actually advising a school board, I wouldn't go there. And nearby, a school board in Black Horse Pike, New Jersey, did go there. And they got sued and they lost. Yeah. All of these cases were coming down between Levy-Weissman and Santa Fe v. Doe based on this concept that Levy-Weissman left open the possibility that you could have student prayer that is private and therefore not state action. That's the argument. So I come at Santa Fe when I teach it from the perspective of, well, what really is state action here? And also the claim is that because it's private speech of the students, that's what the school district claimed in Santa Fe, that it's not government speech. But if it is private speech in a limited public forum, then you have to allow dissenting speech. And so we also look at whether or not, the argument would be essentially you have two choices, as the school board in Santa Fe. One is you violate the free speech clause because you're favoring majoritarian speech and not allowing dissenting speech, or you acknowledge that it's obviously not a free speech situation. And so the real question is endorsement or coercion. And so, I actually take the students into it through those paths. So looking at after Levy-Weissman, what happened? And then is this really private speech? If it's not private speech, it is state action. And what does that mean? If it is private speech, what does that mean, since only the majority is able to, the representative of the majority is able to speak? It's still a government controlled forum. So what, even if they claim it's a limited public forum, what does that mean? And so that's how I come at it.
Okay.
So it raises interesting questions.
See, I come at it from not free speech or establishment. I come at it from the fundamental principles of American democracy. And I hone in on some language in Santa Fe, which in retrospect is unfortunate. So I look at it from the perspective, we're not looking just at forums. We're not just looking at establishment, but we're also looking at the role and purpose of elections in the context of the integrity and foundation of the Republic, which of course after January 6, 2020 becomes a much, much more important concept. So here is the case in which I try to embed establishment and free exercise within a broader political, a more fundamental political question, drilling down to what I view as the most horrifying part of a well-meaning opinion, which is the breezy dismissal of elections as always guaranteeing that it will be the majority and their representatives that will always be elected. At which point I suggest, well, if that's the case, then we've had at least two presidents who should never have been elected. One of them a Catholic in 1960, and the other an African-American in 2008. And therefore, that kind of language becomes dangerous. One, because it's dismissive of the very thing that we now find impossible to dismiss as central to our republic and its organization and the preservation of establishment. And the other is that is absolutely wrong and quite dismissive of the nature and maturity of the American Republic. So we have these discussions.
You can come at that. It's an interestingly different take on that election, because I read Stephen's opinion to be saying not that the majority of demographically will always win, but that whoever wins the election is always a representative of the majority, and therefore, since the public forum doesn't allow other speech, I always go through this sort of thing.
But then it's the forum. My problem.
So I do focus on the forum. So
but this is fabulous, because this then goes to the question of, well, what are you focusing on? Are you focusing on the forum? And here the court plausibly can focus on the forum or the process. If you focus on the process, then you get in a situation that maybe, given the way this worked, that we should have a co-presidency of Trump and Biden. If we apply the same notions. Well, of course, at this point, everyone erupts, No, you're not doing this right. I said, but then what is the way in which one ought to embed? You've got three critically important principles of American governance. Three normative principles. How do we deal with them? The court dealt with two and dismissed the third. In 2024, if this case comes back up, given the new alignments, where are we going to wind up?
Well, that's the current court. I mean, obviously, there's not likely to be a school prayer case going before them for some time, but there are some things percolating. And so it is really interesting there. I mean, it's funny because I use, in a very similar way to what you use Santa Fe to talk about, I use Kitzmiller because they're the school board, and they got voted out. And so the question is, were they really representing the will of a community that seemed, is portrayed in the media as sort of this dominantly intolerant community, or were they just people who essentially got in under the radar, and then once they were found out, they got voted out? So it is an interesting, it's an important issue. It's just funny, we use just two different, and I think part of it is our reading of Justice Stevens' opinions, right? I read Justice Stevens' opinion in Santa Fe as being about sort of majoritarian speech always winning, but I think your reading is just as plausible, which is that it's a more broad statement about elections. So that it's a fascinating, here we are, we're talking about this. I don't think either of us had ever really talked about how we approach this case specifically, other than, some of the broader concepts of it. And so it's kind of cool in these videos that we're hearing each other talk about a pedagogy that where we come at, and we're getting the same issue sometimes using different cases. So it's kind of fun to see.
That's right. Yeah. But of course, no, as you were talking, I was going, oh my God, now I have to add something else. Because as you were speaking, I go, my God, Frank is talking about John Kennedy's Profiles in Courage book. You remember there's the one chapter about the guy who prevented Andrew Johnson's impeachment in the 1860s, who was then hounded out of office because his electorate wanted him to impeach, but his conscience said no. And so then all of this, and his conscience is, of course, religious. Wow, I'm going to have to think about this and see if there's, so thank you. I'm going to see if there's a way I can bring this in. But
although I will go on record as saying I wish Andrew Johnson had been impeached, but you know, had been convicted. He was impeached.
Yeah, that's right. But beyond that, the case is actually fascinating for what it as a codex for what you started out with yourself, your role as a lawyer who is then counseled by these school districts or whoever, who then come to you and say, Lawyer Frank, help us figure out what can we do. And so here for me, the question is, so I had my students play that role. I say, well, okay, would it still be possible? It's clear that it is that nasty combination of whatever it is that the students are doing, plus the oversight, control, or management by the state, the school officials, putting aside the connection between that and elections. This is a real issue, and one that is quite concerning given the line of cases. So what happens if, in fact, what you do is you create a space where the state doesn't interfere, it becomes passive, but it signals somehow or fails to signal and then leaves the space open for parents, civic organizations or the like to fill the void?
Well, you know, and that's been an issue in a lot of situations. So you get schools all over the country that are, you know, quietly favoring majoritarian religious groups or practices in what they claim to be public forums. In fact, after Santa Fe v. Doe, the 11th Circuit, in a case called Chandler v. Siegelman, essentially tried to overturn the Supreme Court in a ridiculous, one of the most ridiculous opinions I have ever read was the post Santa Fe v. Doe Chandler v. Siegelman opinion. It is one of the dumbest court opinions I have ever read, because essentially
for our listeners, notice we do not hold back.
Yeah, I'm not holding back on this. It is an opinion that is remarkable in its activism and denial of reality, which actually nowadays is probably not as shocking as it was then. But basically they said, well, graduation ceremonies it's a public forum. But meanwhile, so the prayer that was voted for was allowed at the public forum. It was always Christian prayer in that district. And you know, actually it wasn't just the district, it was a state law that was involved. But the reality is that, you know, there's no opportunity for dissenting speech. If a graduation ceremony or a football game prayer was truly going to be open to free speech, you'd expect somebody to be able to go up there and say Principal Smith is terrible, is a jerk, is horrible. You'd expect somebody to go up there and talk about, you know, I want to support reproductive freedom. You'd expect somebody to be able to go up there and say anti-religious things. You'd expect somebody to be able to go up there. I mean, even if you limit the amount of time and do it on a first come, first served basis, you'd expect there to be the ability to have dissenting voices. What I've advised, there's a school district in my area that has repeatedly, you know, sort of favored religious groups in, particularly Christian religious groups in their, what is, I think, very much a limited public forum for student groups. But what I told the parents is, look, I mean, I'm not your lawyer. You need to go talk to somebody who, you know, but these are friends of mine. And what I said is, you know, if they're saying to you that it's a public forum, see, you know, and they're letting in the Gideons also, like outsiders, have them say Planned Parenthood, you know, call Planned Parenthood, say we want to distribute condoms.
Right. So
and see if they let them in. If they let them in, then it really is a public forum, and you shouldn't really, there's nothing you can do about it.
So here's a hypo for you. You're the lawyer, you're sitting in your office, and I come in and I say, look, I've just heard that, let's say a majority, 70% of the football teams are all members of Church X. And they've let it be known that because of their opposition to all of this control, that they have informally agreed to meet, and they've told everyone through their churches, and not the school, but through their churches and through people, including members of the school, teachers and faculty who are church members, but acting as church members. They've leafleted the town and they say, look, we can't do any of this stuff officially at school, but you are all welcome to join us at the flagpole or join us in front of the stadium, where we will meet for a moment of devotion to X. And then we will all come in and do whatever it is that the school does. Good, bad response?
You know, I mean, it's very much like a see you at the poll, but just much more organized. You know, my response to that, you would, you know, thinking it through, is most of it's actually fine. It's okay. It's before school hours. But
or before a game.
The question is the participation of the principal and the teachers, and whether or not that is problematic. And a lot of that has to do with when it is, are they actively promoting it? You know, I think that 10 years ago, the participation of teachers, and we saw a lot of lower court opinions like this,
right,
of teachers or principals and see you at the poll was pretty clearly unconstitutional.
right.
But the participation of students was fine.
Which is why I brought the hypo up.
Exactly. Yeah,
so
and today I'm not sure. You know, I'm not sure that the current SCOTUS, and that's how lower courts might view it, would see this as a problem to even have the principal and the teachers involved. You know, you see there are some schools where the team is very heavily influenced by or members of the Fellowship for Christian Athletes or something like that, right? And they do have sort of a voluntary prayer before games, but it's among the players. And obviously, you know, it's that kind of thing might be fine. If the players are choosing to do it. It's more of a problem when the coach is promoting it. This is different from see you at the poll. Or when the players doing it are using it in a manner. There was a case in before Santa Fe v. Doe, also out of Texas, where a Jehovah's Witness cheerleader did not join in the prayer and was called a Satanist and all of these things. And so the you know, and she just couldn't join in the prayer with the cheerleading group simply because of her religious beliefs and the problem, just, you know, not disagreeing with their ability to have a prayer, but she just couldn't participate. And so, you know, the extent to which that otherwise allowed or okay activity of players getting together leads to an environment that might be problematic. But that's a harder question, because now you're dealing with the student group. The cases where the coaches are encouraging it I don't know anymore, but they, you know, things with the current makeup of the court, I don't know what would happen. If it went there, but coaches encouraging it was always a problem. I mean, always unconstitutional.
Especially if the coaches and the principals are also members of the church that are sponsoring it, and they would take the position that, look, it's not me, I'm a congregant, and now we are getting close to that unhappy marriage of free exercise and establishment. You are now interfering with my rights as a ex-member. But it all goes, but this is actually, I was being sneaky, because this actually then gets us to the heart of the next case of Wallace, which is intent and evidence and what is going, and consequence, right? And so we have this case. I know my students find it takes a while to wrap their heads around the quite small but quite potent issue in the case, right? What's the big deal? But it's that nice doorway to, history and intention, which unintentionally becomes a two-edged sword. I love the history part of this thing, and the happy or unhappy world of interpretation. How do you deal with that in your?
It's just a fascinating case. I mean, the two things, this one there's two things I really want the students to get out of it. One is just to take the elephant out of the room, is all 9 justices agree that a properly done moment of silence is okay, right? And they also seem to agree that as applied, and there's a case out of West Virginia where a moment of silence law was applied in a way that discriminated against a Catholic student and a Jewish student, right? And so all 9 justices, including the dissent, seem to agree you can't apply a moment of silence law in a way like that. So then I always shift the focus to exactly what you're talking about, which is the interpretive question, right? What does it mean to look at the intent of a legislature? What kinds of intent are being looked at? I tend to use Justice Berger's dissenting opinion as a really good contrast with sort of the majority and concurring opinions, because Berger makes a lot of really good statements about the problem of relying on individual statements of legislators, particularly ones that might have been made after the facts of the case. And we see a little bit of this in the dissent in Edwards v. Aguilard as well. Right. But it's a really important point. The problem with Berger's dissent is he doesn't really, I think he just does a really nice job of talking about that, but he doesn't really address one of the big thrusts here, which is you don't need to rely on the statements of the legislature by themselves when you've got this pattern of drafting where you don't need to go beyond what the 3 statutes said, and the one under challenge in Wallace, the only thing it did was add prayer. And
which is a nice old-fashioned simple textual analysis.
Yeah,
adding the other stuff then confuses the issue. Or
exactly.
Complicates it.
It does complicate it. I mean, I think the way they do it, it reminds me a little bit from the free exercise area of Lukumi Babluai, where you've got the intent, you can look at what the city of Hialeah did there. Mm-hmm. And it's really clear they were discriminating against Santeria. Oh, yeah. And then you have the statements, and that's just sort of icing on the cake. And that's kind of how I read both Wallace v. Jaffrey and Edwards v. Aguilard. You don't really need the statements, but they are icing on the cake. They reinforce the reading of the 3 statutes, but even without the statements, it could come out the same way. And that's really the weakness in Berger's dissenting opinion. I think he does a brilliant job of talking about the problems of using simply statements by legislators as the proof of legislative intent, because that's really problematic. I'm not a textualist by any stretch of the imagination, but
I love playing with textualism. It's my favorite. All right, but now I'm going to complicate your life. All right, you have now gone out on a limb, and I'm going to use a 3-headed saw to see if I can saw you off. All right, if what you say is true, then and the complications then become very problematic when you put this case up against how the judges use their interpretive powers for figuring out what went on in Galloway, where those changes were then viewed as going in the opposite direction, and then how they viewed it in McCreary, where they looked at it again from a perspective that's more like this. And so sometimes what I'll do is I'll take the 3 cases and say, look, here you go. In each of these cases, you get called on something, you make a change. In 2 of the cases, that is evidence of bad intent. In the 3rd case, that's evidence of, wow, a pure heart. What's the difference between the 3?
Well, and it's the judges. I mean, it's who's in the majority. One of the things I tell my students very early on, when you're looking at the Supreme Court, the most important rule set, sometimes is the rule of 5. It takes 5 to win a case. On an intermediate appellate court, it's the rule of 2, right? And obviously a trial court, it's the rule of 1. But or if it's jury, it depends on the makeup. But how many people are on the jury. But the reality is that I don't think there's any question about that. And in fact, there's another example of that in Wallace, which is Justice Rehnquist's dissenting opinion.
Yes.
You can compare Justice Rehnquist's dissenting opinion to the majority opinion in Everson v. Board of Education. And I always tell my students, and Rutledge's opinion in Everson, right? And I always tell my students, when we do Everson, wait, you're going to see a historical approach that has just as much potential support in the historical record, that comes to the exact opposite conclusion. That's really Rehnquist's dissent in Wallace. And there's other opinions in between, but it's also who is wielding the history, right? And so it's the same. You can look at, I think, 2 of the best histories of the Establishment Clause are Philip Hamburger's and Leonard Levy's. They're diametrically opposed to each other. And the argument you sometimes hear is, well, this one's right or this one's right. I would say, well, they both make really important and supported points, which suggest that originalism is just a cover for what the judges want to do. Right. And originalism is, rather than being judicially conservative, originalism is just a cover for other things that are, and rather than acknowledging those other things, either group is using originalism to sort of cover up. I think Everson was really based more on navigating pluralism at a time when it was being understood, right? Whereas what's going on today on the court is maybe a retrenchment of dominant religion. And so we see that certainly in cases like Espinoza and Galloway, and one's free exercise, the others. I'm wondering if we'll see it in Carson v. Macon this coming term. So
I would not be surprised. But also the opposite is true. So when I look at Wallace, I say this is the Everson problem again, and you really hit the nail on the head here in a wonderful way. I said, so why is it that in Wallace, for purposes of statutory interpretation, the person who introduced the bill and had the biggest mouth, their intent is dispositive over the other 190 people who voted for it? And if in fact what you're looking at is the intent of the legislature, are you looking at the intent of the biggest mouth? Or are you looking at the intent of the majority of people? And that requires polling, but polling becomes impossible. And then you extrapolate it back and to your originalism argument. And the question is, well, when you're recreating history, who are you going to privilege, right? Are you going to privilege John Adams or Abigail Adams? Are you going to confine Abigail to 0? She doesn't exist, and John does. And you've got 4 million people in the US, right, in the 1790s, but only 2 of them, sometimes 3 with George Washington, Jefferson and Madison, appear to be the only 2 people who live somewhere between Maine and Florida during the generative period of the thing. And that makes people, so how you
this is a problem with both with both originalism and the same sort of view for legislative intent. I mean, one of the great hypocrisies of, I think, some of Justice Scalia's jurisprudence is that I think he called it on legislative intent really well. You see that in his dissent, I think in Edwards, but basically, so he points out, that how do we even know that a given legislator, let's say we even do know part of their opinion of the 190, but people don't always operate from one perspective. People make decisions for many, humans aren't, it's not just, although maybe recently it's become more, we just want to get that side or that side, but for the most part, legislators might have many different intents, right? But the problem is that for Scalia that was just as true of the framers, and more importantly, it was just as true their understandings of things. It's not just, it's not just what did the framers think, it's what did they understand, how were things understood at their time. But at that time, we were in a period of huge transformational change. So the same thing, even in the same person, or even in the same state, or the same group of people, or the same nation, may have been understood many different ways.
Right.
And looking at a dictionary from a given time is not all that helpful, because it's going to capture maybe the 10 years before the dictionary, but maybe not what was going on at that time.
Right. And then you wind up doing precisely what Scalia wanted to avoid in coming in advancing originalism, which is you begin to make it impossible to view the judiciary as being in the service of something other than their own perspective.
Right. A lot of the most hypocritical decisions that I've read, not just in the Establishment Clause context, are based in originalism. I'm not saying there aren't decent
and interpretation too. And
yeah, well, I mean,
you got hypocrites all across the spectrum.
It's a different kind of hypocrisy, right? To me, the one is living Constitution. Now I'm going to do what I want, right? I mean, it's sort of a little more blunt. Whereas you get sort of the Scalia-esque originalism, which is we're not changing the law, we're not changing the law, we're not changing the law. We're going to say the framers believe this. We just completely changed the law, but we didn't change the law.
Right.
Because
I know, because I know, because I happen to read these 3 books, and that's all you need to know.
And it's amazing how the original intent, depending on who's writing, tends to be, you've got, Justice Stevens' framers over here, Justice Scalia's framers over here. And so, I mean, and the irony is nobody's wrong, necessarily. I mean, there are people who have written, maybe things that are incorrect historically, just as a matter of fact. I'm sure we all do that at some point by accident, but the reality is that it doesn't mean that Justice Stevens is wrong, and it doesn't mean that Justice Scalia is wrong about some aspect of what was understood.
Touching different parts of the elephant.
Exactly.
Right. But the problem is, it does mean we're all going to be textualists now.
Well, yeah, I mean, I'm not to me, textualism and even originalism work really well when they work. And that means they work really well when the text is clear as applied to the facts. Right. And both of those things.
Right.
And,
but even that's not
always.
Right. As Justice Thomas continues to remind us, the word commerce meant something very, which could be as clear as can be, unless you happen to be in 1791 or 2021. And then, we got, this is a problem.
He wants to go back to commerce precedes manufacture or succeeds manufacture. But yeah, I mean, to me, it's I mean, bear in mind, you and I both also write, in addition to law and religion, we write about law and interpretation. And, I'm a bit of a Gadamerrian, but to me, Gadamer's point, and I understand for a lot of people that's heretical, but I don't read Gadamer the way that critical theorists read Gadamer. Gadamer was not normative at all. Gadamer was just saying people project preconceptions into interpretation. So that's going to happen when you're reading what you think a legislator is doing. It's also going to happen when you're reading what framers are doing. But you have to also try to fuse horizons. You need to understand your projecting. And so I think that you can look at the answer to your 3 scenarios, right? The McCreary County, the Galloway, and Wallace, and what you see is it really is about, in some ways, the preconceptions of the judge. This isn't like a Derridian everything's subjective kind of approach. It means you're bound in your
oh my God, I thought that's where you're going. I'm going to raise the flag of Derrida.
Yeah, and what I'm saying is, yeah, it's not Derridian, right? Derrida would say, it's all destroying, but I mean, the reality is that there's this idea, and this dualistic idea in the West of objectivity and subjectivity, but everything's mediated by context.
That's right.
And so
it's the objective subjectivity of semiotics.
Exactly, or hermeneutics, right? And so the reality is that when we look at this stuff, when we look at these cases, it's not that these judges have certain judicial
Approaches. Right.
traditions that they
Right.
subscribe to, and those judicial traditions, it's not purely I want to do this or even something that's purely conscious, but certain traditions impact certain judges, and it ranges from the traditions they grew up in, maybe religiously, but or otherwise, but it also includes their judicial perceptions, textualism, originalism, you know, and so I think that explains.
Yeah,
I think
and
that
the
explains it.
semiotician, right? And the semiotician would say, well, that's absolutely right. And what we're really seeing is that everyone starts from the constraints of the meaning universe in which they abide, and then they remain true to it. There's no strategic, but that truth can itself then be at odds with others. And that causes the kind of what we've been talking about today, this range of plausibility, none of which is impossibly wrong, but all of which are to some extent incompatible, because once you get underneath.
And that's the beauty, you know, if you can come, like you can look at sort of Gadamer and Peirce, and this, you know, the two views of the same mountain that are actually looking at the same part of the mountain, right? And yeah, I think, you know, the beauty to that kind of an approach to a semiotic or at least philosophical hermeneutic approach is that there is a range of plausibility in semiotics and hermeneutics, a range of possibilities. But the reality is that what that does mean is that there are certain things where from a hermeneutic perspective, the horizon of the interpreter, what the interpreter can see, could overwhelm the text, the situation the interpreter's interpreting, and that's a problem. But what it means is that you know, the objectivist idea, this is absolutely right, you know, this is absolutely right at every level, epistemologically, whatever, to the, you know, idea that this is absolutely wrong, but there's this whole middle area, which is a range of answers that could be right. And so it doesn't mean that there's always going to be agreement. The question is, what, as lawyers and as law professors and as people engaged in law and religion, what do we do with this? Because law and religion now, we have so many splintered views. You know, Galloway would have never happened 10 years before Galloway.
That's right.
Right. Galloway would have come out more like Allegheny.
That's right. That's exactly
and so
right.
we don't know. What do? You know, like Holmes, you know, what's the path of the law going to be? Right.
Or as the semiotician would say, how do you rationalize this meaning universe within a collective that doesn't want to, that cannot afford to be fractured? And that involves, and you're absolutely right, it involves recognizing this middle ground, but then developing some kind of rational basis for figuring out where the borderlands are, understanding that those borderlands are subjective in the sense that they represent our subjective understanding of ourselves in this republic as creatures of our principles, of our core principles, but that, you know, to the extent it's theoretically subjective, it's actually quite concrete. These are the choices we made in becoming who we are. Within it, there's space for, as Frankfurter would say, case-by-case application. Outside of it, you're beyond the tolerance levels of the interpretive community.
Yeah, I mean, other than the term subjective, I would agree with that. I mean, I think that,
I know you.
You know, I think that what you're describing is very, very accurate. But it's a kind of a cultural embeddedness, right? So our idea of law and religion, our ideas of establishment, that where these come from, there is a certain cultural embeddedness. I wouldn't call it subjective or objective, but I would say that, I guess, the way Western dualism views these things, it's more like subjective than objective. I just never buy into the dualism of objective subjective, but you know, that's a but other than that one term, but I think the way it's understood in the West, it would be viewed as more subjective.
Right. Right.
And so, you know, so I agree with that. And interestingly, what you said explains, you know, how you navigate Wallace, McCreary, and Galloway, because essentially what you say is these are, Galloway is inconsistent with the other two, which seem reasonably consistent with each other. But I think it's great you mentioned Frankfurter, because what we have going on here is different contexts. And so you can make sense out of it if we look at it contextually.
Right.
But it's very important that the students understand, and for those of you teaching the material to understand as well, which I'm sure you do, is that we just have to live with the ambiguity of it, right? I mean, the reality is the court changes, and we see in Law and Religion these ebbs and flows of precedent. And so, you know, we just have to sort of live with that ambiguity of McCreary County and Galloway, which were decided within 10 years of each other. Right. And, you know, then the American Humanist case comes down, and but it doesn't say McCreary was wrong. And so now how do we navigate? So, I mean, basically doesn't say it was right either, but I mean, so we, you know, I think that it raises a really good point, and maybe Frankfurter's advice is in that sense good advice for students learning Law and Religion, and faculty writing about and teaching Law and Religion, which is we have to understand that contextual ambiguity, as well as, I guess you could call it judicial demographic ambiguity, you know, who's on the court and who's saying what, you know, it does impact this, and that's okay. Embrace it. And I tell my students in torts with proximate cause, embrace the ambiguity. It will set you free. You know, because
and don't be afraid to make a judgment. And now you And now you sound like Breyer's concurrence in Van Orden.
I don't want to sound
like there. We're going to get
Breyer's concurrence in Van Orden was an example of, I'm using the endorsement test, but I'm going to say I'm not using the endorsement test.
But we have to make hard choices, and this is one of those hard choices, and we have to use our judgment. And he might as well have changed his name to Frankfurter.
Yeah, and I have a theory, actually. It's funny, on Breyer's, I actually wrote this in a book and in an article, that, you know, I really do think that Breyer I think he was very conscious of the court's capital, right? And the court has a limited amount of political capital. And given that Van Orden and McCreary County were coming down the same day, several years after September 11th, when the country was in a patriotic, situation that was, you know, you could see what happened after the Newdow case came down in the Ninth Circuit, and you know, people who should have known better about the history of the pledge, which the history of the pledges of the adding of the words is somewhat problematic, and anti-Catholic and atheist, maybe in some cases anti-Semitic as well. But you know, Breyer, I think, saw, look, if both of these cases come down against the Ten Commandments at this moment, we may lose so much political capital. And I actually went and looked during a conference when I was in Austin at the monument, and it's actually really hard to find, and you can see 15 other monuments from there. And I think Breyer's perspective was this one just isn't that problem. I actually think you should just use the endorsement test and said it passes, because I think it should have passed. I refused to. I signed a brief in McCreary County. I signed on to an amicus brief there, but I refused to sign on to a brief for either side and Van Orden, because I thought both sides were wrong. I thought that the side that was arguing endorsement should apply and it's unconstitutional was wrong, but the side that said endorsement shouldn't apply was also wrong, because my view was you can apply endorsement and it is constitutional. And that's kind of what Breyer did, without acknowledging that it was applying the endorsement test.
All right. So any last words? I'm afraid.
Yeah, that was a lot. Yeah, sorry, audience. We got too into it.
Carried away.
We got a little too into it. So you can tune out whatever parts you want to. Whatever parts you want to tune out.
We are coming back to 10 Commandments. This is a warm up for the 10 Commandments discussion and for the Galway discussion. So I'm Rev.
Yeah,
So
and I love the
last-
fact that you brought that up, Galloway, McCreary, and Wallace v. Jaffrey, because there really is just a perspective issue going on there.
That's right. Any last words then for our listeners?
Just enjoy, see how much we got into it. We've been doing this for many, many years. We've been law and religion people and interpretive theory people since Larry and I have known each other for a very, very long time.
A long time, but we're not going to talk numbers.
We won't say how long, just for a very long time. And I had a lot of hair when we met. And so, what I would say is just really enjoy it. I mean, law and religion is just so interesting, but it's also intellectually just so fun and challenging.
Incredibly
So enjoy
stimulating.
it.
Incredibly stimulating.
Yeah.
All right, with that, stay tuned for our next one, and thank you for listening in.